Hey, and welcome back to the Michael Cohen Show, where we continue our journey to 250,000 subscribers. So thanks to all of you. Look, yesterday, Donald Trump's slow attorney, Todd Blanche, stupidest lawyer of all time, went ahead and filed a second notice of removal of the Manhattan District Attorney's hush money case, where he wants to have the case removed to federal court, especially before the September 18th sentencing date. All right, I want to take a look at this and I want to break it down for you because especially they, of course, have to call me names in this document as well. So let's take a look at the filing. Let's start, for example, with paragraph number 1. First and foremost, they call this a zombie case. Look, I was practicing law since 1992. I've never heard anybody refer to something as a zombie case. And they're claiming that it should have been dismissed long ago. But here's what happened. It was not dismissed. In fact, it was rejected. But they go on to say that the Manhattan District Attorney's Office, it's known as Danny, District Attorney of New York, violated the presidential immunity doctrine in grand jury proceedings and again at trial by relying on evidence of President Trump's official acts during his first term in office. Now, of course, they're never going to tell you what those official acts were. What? Paying back money for hush money payment in order to suppress information? I'm not sure what they're talking about. And then they go on to talk about the United States Supreme Court recently ruled that these types of violations threaten the structure of the federal government and the ability of future presidents to carry out their vital duties in the way the framers intended. Dan, what are they talking about? That a future president is going to pay off a porn star not to talk about his mushroom pecker? Seriously? Danny's flawed case is also preempted because their indictment turned on the improper use of state law to try to retroactively police the 2016 presidential election through non-unanimous jury findings. Again, made up. Absolutely nonsense. The supremacy clause, now they go into a third thing. Talk about word vomit here. The supremacy clause violation arising from Danny's overreach are illustrated by the fact that neither federal prosecutors nor the Federal Election Commission proceeded against President Trump based on the allegations that Danny relied upon. They're making assertions here. They're making assertions here that the FEC has to be involved in this case in order for the district attorney to bring a case. Again, not true. So they go on to say that the supremacy clause, it's not the only provision of the Constitution being ignored in connection with a purely political New York County prosecution. The ongoing proceedings will continue to cause direct and irreparable harm to President Trump, the leading candidate in the 2024 presidential election, and voters located far beyond Manhattan. This harm includes First Amendment violations, as Justice Merchan has maintained a post-trial gag order that restricts President Trump from engaging in political advocacy based on valid criticisms of the New York County proceedings. Again, drop this down for a second. This is pure and total bullshit. It is a total lie. First and foremost, let's start with the fact that he is not President Donald J. Trump. He's former President Donald J. Trump. Second, they are throwing everything that they can into this motion because the first one failed and failed miserably, just as this should. Let's go to the next paragraph because this just doesn't stop. Where they say, lastly, Danny's star witness and serial perjurer, talking about me, Michael Cohen, testified regarding President Trump's official response to federal investigations he oversaw as president, including testimony regarding an alleged conversation with Attorney General Jeff Sessions and separate references to President Trump's use of the pardon power. Danny relied on similar proof before a grand jury, and that evidence also violated the presidential immunity doctrine under Trump v. United States. Let's drop that down for a second because before we go on, At no point in time do I recall ever having a conversation about Jeff Sessions, nor was I asked any questions about Jeff Sessions during the time of trial. So again, I have no idea what Todd Blanche, the sloat, the stupidest lawyer of all time, is actually saying here. It's merely to just to placate Trump and to throw in more shit about me. Serial perjurer. Let me just start by saying, you know who turned around and said that I didn't lie? You know who said that? Well, clearly Judge Merchan. You know who else? The 12 independent jurors that came back with a unanimous determination on 34 counts of guilt. They're the ones who matter here, not what Todd Blanche has to say. So let's go to the next paragraph, because this shit only gets better and better. And stay with me here, because this is important. If attacking Judge Merchan, attacking me, attacking everything so far wasn't enough, well, now you got to throw in Judge Merchan's daughter, right? So President Trump's post-trial motion to dismiss the indictment and vacate the jury's verdicts based on presidential immunity, by the way, which didn't come into effect till after the case was already tried and decided. It's currently pending for Justice Merchan. Yeah, that's a true statement. An acting New York judge facing conflicts of interest and appearances of impropriety, who had already forecast his intention to deny the motion by directing the parties to prepare for sentencing in September. I mean, that's how the system works. You're told when sentencing is. This month, President Trump renewed prior requests for Justice Merchan's recusal based on part on 2019 public statement by Justice Merchan's daughter, indicating that he had been critical of President Trump's use of Twitter during his presidency. The problem with Justice Merchan's earliest statements is that they confirm judicial bias and hostility towards President Trump's 2018 tweets, which are a core issue in the pending presidential immunity motion. No, they are not. They are not. Again, this is all bullshit. But Justice Merchan denied the recusal motion without even addressing that issue. There was no issue to address. He claimed, and of course in the sloat's opinion, incorrectly, that there was nothing new about the recusal motion, despite the fact that the motion connected evidence of a specific form of judicial bias to President Trump's immunity arguments. Not true. Again, absolutely not true. Let's go to the final paragraph. The conclusion. The conclusion here. For the foregoing reason, President Trump respectfully requests that the court, at least he said respectfully, promptly order People versus Trump removed to the Southern District of New York, and to confirm that Justice Merchan may not sentence President Trump during litigation over this removal, because sentencing would result in a prohibited judgment of conviction under 28 U.S.C. 1455. Judgment, right? I mean, could you imagine what we're talking about here? Let's drop this down. This is a gigantic word vomit document that throws anything and everything into the case. For what? For the sole purpose of creating delay. For the sole purpose of creating feelings by people that you cannot trust the Justice Department. You cannot trust the judges when it comes to anything with Donald Trump. We have seen time and time again, Donald Trump attacked those that tried to hold him accountable, as others have been held accountable. But then again, you have a judge like Judge Eileen Cannon, who is every single thing that she has done. First of all, has been overturned by I think it's the 11th Circuit, and who actually has gone out of her way within which to make up law for the benefit of Donald Trump. But that's okay. That's not one that he's going to fight, of course. He's only going to continue to fight to throw mud at anyone and everyone that wants to hold him accountable for his dirty deeds. My friends, this is not the type of person that we need or we should have controlling the levers of power here in the United States, a man who I regularly talk about, has stated emphatically that he wants to rewrite the Constitution. He wants all powers to be conferred with him. What do you think is going to happen to the other remaining open indictments? The January 6th case, the Mar-a-Lago documents case, the Fani Willis Fulton County attempt to interfere with a free and fair election case, now the superseding indictment. What do you think is going to happen to all of those? How do you ever hold somebody accountable when that person refuses to allow the system that guides us all to hold him accountable? And the answer is you will not. The man will have the power of the king, the power of a monarch, a ruler, supreme leader, the Führer. And that's not who we want. And it's why I will end this episode by saying, as I always do, it is imperative that we vote Harris Walz 2024. Hey, everyone. First of all, thanks for watching. I mean, we're going to be posting daily episodes with reactions and talking about politics. We'll be talking about everything, in fact. So please like and subscribe. Join us on this journey.